She walked in laughing. That was the first thing everyone noticed. Not her entrance, not her outfit, not the thick accordion folder she carried under one arm like a professor heading to a lecture she was already bored by. It was the laugh, easy, unhurried, the laugh of someone who has already decided that nothing in this room has any power over her, and finds the premise of being here mildly entertaining. She was still finishing a conversation with someone in the hallway when the door swung shut behind her, still smiling when she turned to face the bench, still carrying the loose-shouldered energy of a woman who believed, with total sincerity, that she was the most legally informed person in Courtroom 6 that morning. Her name was Cheryl Fontaine. She was about to stop laughing. Judge Frank Caprio had seen the file. He had read it the night before, actually, because something in the preliminary paperwork had caught his attention, not the citations themselves, which were unremarkable, but the responses to them, the notices she had sent back to the court, the language, the structure, the particular combination of confidence and complete legal incoherence that he had learned, over 30 years on this bench, to recognize the way a doctor recognizes a rash. He knew exactly what was coming. He had arranged his patience accordingly. If you already know what sovereign citizen court appearances look like, and you are here for every second of what is about to happen, drop a comment right now with the word laughing, because by the end of this, the only person in Courtroom 6 who will not be smiling is Cheryl Fontaine. Subscribe if you haven't, because this is the kind of morning that reminds you why some people should never underestimate a quiet man in reading glasses. Cheryl Fontaine was 44, a self-described private national and creditor of the Republic, according to the cover page of the documents she had pre-filed with the court, documents the clerk had received, logged, and placed in a folder labeled with admirable neutrality, Respondent Submissions. She dressed for the occasion in the way people dress when they want to signal that they are taking something seriously on their own terms. Dark slacks, a structured blazer, reading glasses pushed up on her head like a woman who runs meetings. She set her accordion folder on the defendant's table with a decisive click and began organizing her papers with the crisp efficiency of someone who has rehearsed this moment extensively. The gallery watched with the particular fascination people reserve for things they cannot quite classify. Judge Caprio let her settle. He greeted her with the same warmth he gives everyone, genuine, unhurried, without performance. "Ms. Fontaine, good morning." She looked up from her papers and said with a bright and slightly patronizing smile, "Good morning, Judge," or, well, I should say, good morning to the man acting in the capacity of judge in this admiralty proceeding. She said it pleasantly, the way you correct someone's minor factual error at a dinner party. "I just want to make sure we're operating with full disclosure about the nature of this venue." The gallery did not laugh. It went very still instead, the way a room goes still when something unexpected has been placed on the table and nobody is sure yet what it is. Judge Caprio looked at her over his glasses for a moment. Then he said gently, "It's a traffic court, Ms. Fontaine. We can proceed." She had been cited twice in the previous 4 months, once for driving with an expired registration, once for driving without a valid license plate. The fines totaled $260. In response to the first citation, she had mailed the court a 14-page document declaring herself a sovereign, non-corporate, flesh-and-blood woman of the land jurisdiction, notifying the court that she did not consent to its jurisdiction, that her travel was an inalienable natural right, that the officer who issued the citation had committed a commercial trespass, and that she was billing the municipality $400 per hour for her time in responding to what she called fraudulent presentments. The document was notarized. She had notarized it herself, having become, according to a footer on page 11, a public notary of the private international record. The clerk, in 11 years, had seen many things. She had not seen that. Judge Caprio had reviewed all 14 pages, every footnote, every UCC citation, every reference to the law of the sea, the gold fringe on the flag, and the 1933 bankruptcy of the federal government. He had not rolled his eyes. He had not laughed. He had read it the way he reads everything, carefully, completely, and with the quiet intention of being able to respond to every single word of it. That's when everything changed, because Cheryl Fontaine, still smiling, produced her opening document and began to read aloud. "I, Cheryl Ann of the family Fontaine, a living woman and sovereign national, hereby place this court on notice that any attempt to compel performance under color of law constitutes a violation of my secured party creditor status under UCC Article 9 and will be met with a commercial lien of no less than Ms. Fontaine. The judge's voice was not sharp. It was the opposite of sharp. It was the voice of someone turning off background noise so the room can hear what matters. She stopped. "I've read your filing," he said. "All of it. I want you to know that because I want what I'm about to say to land clearly." He folded his hands. "The Uniform Commercial Code governs commercial transactions between businesses. It does not govern traffic stops. The law of the sea, admiralty jurisdiction, applies to navigable waterways, not public roads in Providence, Rhode Island. The 1933 argument has been rejected by every federal court that has ever considered it, and a notary cannot notarize their own documents. That is not a technicality. It is the entire point of notarization." Cheryl Fontaine's smile had not disappeared, but it had changed. It had become the smile of someone holding a position under new pressure, maintained by will rather than ease. She pivoted. She produced a second document, a common law copyright on her name, which she explained meant the court could not use it without her permission, and by doing so had entered into an implied contract. She explained that the license plate requirement was an unconstitutional compelled commercial activity. She explained that she had a right to travel that superseded vehicle registration law. She said all of this fluently, confidently, and rapidly in the way people speak when they have memorized a thing so thoroughly that the words come out ahead of the thoughts. Judge Caprio waited. He waited until every word was out. Then he said in a voice so level it could have been used to hang a picture frame, "Ms. Fontaine, may I ask, where did you learn this?" She brightened. "I've done extensive research. There are educators online who have decoded the actual law and—" "Online," he said. "Yes, and there are documented cases where—" "Can you cite one?" he asked. "One case in any American court, at any level, where a sovereign citizen argument succeeded?" The smile flickered. She looked at her papers. She found a case name, mispronounced, that upon the judge's gentle inquiry turned out to be a dissenting opinion from a 1987 case about an entirely unrelated tax matter. The courtroom went silent, completely, profoundly silent, not mocking silence. Something more uncomfortable than that, the silence of watching someone discover in real time that the foundation they built their certainty on was poured by strangers on the internet who were also wrong. Judge Caprio's monologue, when it came, was measured and complete. The people who teach this framework, and I want to be precise about this word, teach it because it gives people a feeling of power and exemption that is very appealing, especially to people who feel that the system has treated them unfairly. I understand the appeal. I genuinely do. He paused. But what they are selling is not freedom. It is a very expensive illusion. Expensive because it doesn't work, because courts reject it uniformly, and because the people who follow it end up here, in more trouble, with more debt, and with less recourse than when they started. You walked in this morning believing you had a weapon. What you had was a folder. Another pause, smaller. And I say this not to humiliate you. I say it because you are clearly intelligent, clearly capable of sustained research and preparation, and you have spent that intelligence on a system of ideas designed by people who will never stand where you are standing right now and face the consequences of those ideas. That, Ms. Fontaine, is the real fraud. The accordion folder was still open on the table. She did not reach for it. The fines were upheld in full. She was given 30 days to register the vehicle and obtain a valid license plate, with a compliance check scheduled. The self-notarized documents were returned to her with a written explanation, prepared by the clerk, of actual notarization requirements under Rhode Island law. The judge recommended, as he always does, a legal aid organization. Real attorneys, he noted, who actually argue in actual courts and occasionally win. Cheryl Fontaine gathered her papers slowly. The confident efficiency with which she had arranged them was gone. She moved with the careful deliberateness of someone recalibrating. She did not look at the gallery on the way out. At the door, she paused for just a moment, not long enough to be a scene, just long enough to be human, and then she left. She registered the vehicle 19 days later. The plates arrived in the mail on a Thursday. She affixed them without ceremony. The accordion folder, by several accounts from people who knew her, was not referenced again at gatherings the way it used to be. The man who had taught her the framework through a series of online videos, the educator she had mentioned, the decoder of actual law, posted a new video that same month explaining why court losses didn't count, because the courts themselves were illegitimate. It had 40,000 views by the following weekend. Somewhere in the comments, someone asked if it had ever actually worked for anyone. The question had 63 replies. None of them contained a yes. Judge Caprio called the next case at 11:04. He had 3 more files. He had read them all. If this one made you think, or made you frustrated, or made you feel something complicated about the people who fall into these rabbit holes and the people who profit from leading them there, drop a comment below with the word folder and tell me what you think justice looks like when the weapon someone brought turns out to be paper. Share this with someone who needs to hear what a real judge sounds like when he tells you the truth kindly and completely. And subscribe, because this courtroom understands something that the internet never will. That dignity is not a legal filing. It is how you behave when you find out you were wrong.